To put the same thing in a somewhat different shape, constitutional law, as the expression is used in England both by the public and by authoritative writers, consists of two elements. The one element, here called the law of the Constitution, is a body of undoubted law. The other element, here called the conventions of the Constitution, consists of maxims or practices which, though they regulate the ordinary conduct of the Crown, of ministers, and of other persons under the Constitution, are not in strictness laws at all. The contrast between the law of the Constitution and the conventions of the Constitution may be most easily seen from examples. To the law of the Constitution belong the following rules. The king can do no wrong. This maxim, as now interpreted by the courts, means in the first place that by no proceeding known to the law can the king be made personally responsible for any act done by him. If, to give an absurd example, the king were himself to shoot the Premier through the head, no court in England could take cognizance of the act. The maxim means, in the second place, that no one can plead the orders of the Crown or indeed of any superior officer in defence of any act not otherwise justifiable by law. This principle, in both its applications, is, be it noted, a law and a law of the Constitution, but it is not a written law. There is no power in the Crown to dispense with the obligation to obey a law. This negation or abolition of the dispensing power now depends upon the Bill of Rights. It is a law of the Constitution and a written law. Some person is legally responsible for every act done by the Crown. This responsibility of ministers appears in foreign countries as a formal part of the Constitution. In England, it results from the combined action of several legal principles, namely, first, the maxim that the king can do no wrong; secondly, the refusal of the courts to recognise any act as done by the Crown which is not done in a particular form, a form in general involving the affixing of a particular seal by a minister, or the countersignature or something equivalent to the countersignature of a minister; thirdly, the principle that the minister who affixes a particular seal or countersigns his signature is responsible for the act which he, so to speak, endorses. This, again, is part of the Constitution and a law, but it is not a written law. So again, the right to personal liberty, the right of public meeting, and many other rights are part of the law of the Constitution, though most of these rights are consequences of the more general law or principle that no man can be punished except for direct breaches of law, i.e. crimes, proved in the way provided by law, i.e. before the courts of the realm. To the conventions of the Constitution belong the following maxims. The king must assent to, or, as it is inaccurately expressed, cannot veto, any bill passed by the two Houses of Parliament. The House of Lords does not originate any money bill. When the House of Lords acts as a court of appeal, no peer who is not a law lord takes part in the decisions of the House. Ministers resign office when they have ceased to command the confidence of the House of Commons. A bill must be read a certain number of times before passing through the House of Commons. These maxims are distinguished from each other by many differences. Under a new or written constitution, some of them probably would, and some of them would not, take the form of actual laws. Under the English constitution, they have one point in common. They are none of them laws in the true sense of that word, for if any or all of them were broken, no court would take notice of their violation. It is to be regretted that these maxims must be called conventional, for the word suggests a notion of insignificance or unreality. This, however, is the last idea which any teacher would wish to convey to his hearers. Of constitutional conventions or practices, some are as important as any laws, though some may be trivial, as may also be the case with a genuine law. My object, however, is to contrast not shams with realities, but the legal element with the conventional element of so-called constitutional law. This distinction differs essentially, it should be noted, from the distinction between written law, or statute law, and unwritten law, or common law. There are laws of the Constitution, as for example the Bill of Rights, the Act of Settlement, and Habeas Corpus Acts, which are written law, found in the statute books, in other words, are statutory enactments. There are other most important laws of the Constitution, several of which have already been mentioned, which are unwritten laws, that is, not statutory enactments. Some further of the laws of the Constitution, such, for example, as the law regulating the descent of the Crown, which were at one time unwritten or common law, have now become written or statute law. The conventions of the Constitution, on the other hand, cannot be recorded in the statute book, though they may be formally reduced to writing. Thus, the whole of our parliamentary procedure is nothing but a mass of conventional law. It is, however, recorded in written or printed rules. The distinction, in short, between written and unwritten law does not in any sense square with the distinction between the law of the Constitution, constitutional law properly so called, and the conventions of the Constitution. This latter is the distinction on which we should fix our whole attention, for it is of vital importance, and elucidates the whole subject of constitutional law. It is further a difference which may exist in countries which have a written or statutory constitution. In the United States, the legal powers of the President, the Senate, the mode of electing the President, and the like are, as far as the law is concerned, regulated wholly by the law of the Constitution, but side by side with the law have grown up certain stringent conventional rules which, though they would not be noticed by any court, have in practice nearly the force of law. No president's ever been re-elected more than once. The popular approval of this conventional limit, of which the Constitution knows nothing, on a president's re-eligibility proved a fatal bar to General Grant's third candidature. Constitutional understandings have entirely changed the position of the presidential electors. They were by the founders of the Constitution intended to be what their name denotes, the persons who chose or selected the president. The chief officer, in short, of the Republic was, according to the law, to be appointed under a system of double election. This intention has failed. The electors have become a mere means of voting for a particular candidate. They are no more than so many ballots cast for the Republican or for the Democratic nominee. The understanding that an elector is not really to elect has now become so firmly established that for him to exercise his legal power of choice is considered a breach of political honour too gross to be committed by the most unscrupulous of politicians. Public difficulties, not to say dangers, might have been averted if, in the contest between Mr. Hayes and Mr. Tilden, a few Republican electors had felt themselves at liberty to vote for the Democratic candidate. Not a single man among them changed his side. The power of an elector to elect is as completely abolished by constitutional understandings in America as is the royal right of dissent from bills passed by both houses by the same force in England. Under a written, therefore, as under an unwritten constitution, we find in full existence the distinction between the law and the conventions of the Constitution. Upon this difference I have insisted at possibly needless length, because it lies at the very root of the matter under discussion. Once grasp the ambiguity latent in the expression constitutional law, and everything connected with the subject falls so completely into its right place that a lawyer, called upon to teach or to study constitutional law as a branch of the law of England, can hardly fail to see clearly the character and scope of his subject. With conventions or understandings he has no direct concern. They vary from generation to generation, almost from year to year. Whether a ministry defeated at the polling booths ought to retire on the day when the result of the election is known, or may more properly retain office until after a defeat in Parliament, is or may be a question of practical importance. The opinions on this point which prevail today differ, it is said, from the opinions or understandings which prevailed 30 years back, and are possibly different from the opinions or understanding which may prevail 10 years hence. Weighty precedents and high authority are cited on either side of this knotty question. The dicta or practice of Russell and Peel may be balanced off against the dicta or practice of Beaconsfield and Gladstone. The subject, however, is not one of law but of politics, and need trouble no lawyer or the class of any professor of law. If he is concerned with it at all, he is so only insofar as he may be called upon to show what is the connection, if any there be, between the conventions of the Constitution and the law of the Constitution. This, the true constitutional law, is his only real concern. His proper function is to show what are the legal rules, i.e. rules recognised by the courts, which are to be found in the several parts of the Constitution. Of such rules or laws he will easily discover more than enough. The rules determining the legal position of the Crown, the legal rights of the Crown's ministers, the constitution of the House of Lords, the constitution of the House of Commons, the laws which govern the established church, the laws which determine the position of the non-established churches, the laws which regulate the army, these and 100 other laws form part of the law of the Constitution, and are as truly part of the law of the land as the articles of the Constitution of the United States form part of the law of the Union. The duty, in short, of an English professor of law is to state what are the laws which form part of the Constitution, to arrange them in their order, to explain their meaning, and to exhibit where possible their logical connection. He ought to expound the unwritten or partly unwritten Constitution of England in the same manner in which Story and Kent have expounded the written law of the American Constitution. The task has its special perplexities, but the difficulties which beset the topic are the same in kind, though not in degree, as those which are to be found in every branch of the law of England. You are called upon to deal partly with statute law, partly with judge-made law. You are forced to rely on parliamentary enactments and also on judicial decisions, on authoritative dicta, and in many cases on mere inferences drawn from judicial doctrines. It is often difficult to discriminate between prevalent custom and acknowledged right. This is true of the endeavour to expound the law of the Constitution. All this is true also in measure of any attempt to explain our law of contract, our law of torts, or our law of real property. Moreover, teachers of constitutional law enjoy at this moment one invaluable advantage. Their topic has, of recent years, become of immediate interest and of pressing importance. These years have brought into the foreground new constitutional questions, and have afforded in many instances the answers thereto. The series of actions connected with the name of Mr. Bradlaugh has done as much to clear away the obscurity which envelops many parts of our public law as was done in the 18th century by the series of actions connected with the name of John Wilkes. The law of maintenance has been rediscovered. The law of blasphemy has received new elucidation. Everybody now knows the character of a penal action. It is now possible to define with precision the relation between the House of Commons and the courts of the land. The legal character and solemnity of an oath has been made patent to all the world, or at any rate to all those persons who choose to read the law reports. Meanwhile, circumstances with which Mr. Bradlaugh had no connection have forced upon public attention all the various problems connected with the right of public meeting. Is such a right known to the law? What are the limits within which it may be exercised? What is the true definition of an unlawful assembly? How far may citizens lawfully assembled assert their right of meeting by the use of force? What are the limits within which the English Constitution recognises the right of self-defence? These are questions, some of which have been raised and all of which may any day be raised before the courts. They are inquiries which touch the very root of our public law. To find the true reply to them is a matter of importance to every citizen. While these inquiries require an answer, the study of the law of the Constitution must remain a matter of pressing interest. The fact, however, that the provisions of this law are often embodied in cases which have gained notoriety and excite keen feelings of political partisanship may foster a serious misconception. Unintelligent students may infer that the law of the Constitution is to be gathered only from famous judgments which embalm the results of grand constitutional or political conflicts. This is not so. Scores of unnoticed cases, such as the Parlement Belge or Thomas versus the Queen, touch upon or decide principles of constitutional law. Indeed, every action against a constable or collector of revenue enforces the greatest of all such principles, namely, that obedience to administrative orders is no defence to an action or prosecution for acts done in excess of legal authority. The true law of the Constitution is in short to be gathered from the sources whence we collect the law of England in respect to any other topic, and forms as interesting and as distinct, though not as well explored, a field for legal study or legal exposition as any which can be found. The subject is one which has not yet been fully mapped out. Teachers and pupils alike therefore suffer from the inconvenience as they enjoy the interest of exploring a province of law which has not yet been entirely reduced to order. This inconvenience has one great compensation. We are compelled to search for the guidance of first principles, and as we look for a clue through the mazes of a perplexed topic, three such guiding principles gradually become apparent. They are, first, the legislative sovereignty of Parliament; secondly, the universal rule or supremacy throughout the constitution of ordinary law; and thirdly, though here we tread on more doubtful and speculative ground, the dependence in the last resort of the conventions upon the law of the Constitution. To examine, to elucidate, to test these three principles forms, at any rate, whatever be the result of the investigation, a suitable introduction to the study of the law of the Constitution. End of the outline of the subject.